Civil Rights Act of 1963. The President's proposed Civil Rights Act would violate ancient concepts of liberty. It would eliminate constitutional guarantees against tyranny, destroying human rights as well as private property rights. Under the pretext of enforcing equality, the President would violate the American principle of equality before the law, setting certain groups of citizens aside for special and preferential treatment, to the detriment of ordinary citizens. Adam Clayton Powell boasts that he wrote the President's Civil Rights message. Powell has had connections with numerous communist fronts. His personal conduct has scandalized the nation. His hatred for white people has been openly broadcast. Kowtowing to such people as this, John F. Kennedy is sowing the seeds of hate and violence, whence the nation may reap a bloody harvest. That is a summary of my report on Civil Rights Act of 1963. The full report after a message from my sponsor. On June 19, 1963, President Kennedy proposed a Civil Rights Act. He asked for federal supervision of elections and for federal establishment of voter qualifications in the South, where it is alleged that Negroes are denied the right to vote. The allegation is false. In the South, voter qualifications, whether they be poll tax or literacy requirements, apply equally to whites and Negroes. The constitutional issue, however, is of overriding importance to the entire nation. When an illiterate, shiftless, irresponsible individual of any race has as much voice in selecting national rulers and in changing the organic law of the nation as an industrious, thrifty, productive individual, what is to prevent the dregs and drones of society from plundering hard-working and productive citizens? Politicians can fan hatred among low-income groups for higher-income groups, telling the masses they are poor because they are oppressed, promising to soak the well-to-do with taxes in order to redistribute the national wealth and guarantee that everyone has his fair share. The Founding Fathers were aware of this danger in democracy. They saw how it had destroyed ancient civilizations, just as anyone today can see how a similar situation creates poverty, wild disorder, and tyranny in many Latin American nations, where politicians go into the squatter slums, buying votes with promises to pull down the high and mighty and to provide free and easy living for the masses. The Founding Fathers wanted a constitutional system in which all, high and low, rich and poor, good and bad, would be equal before the law, all equally free to lead their own kind of life as long as they did not infringe on the rights of others, all enjoying the same guarantees against tyrannical oppression by their own government. But the Founding Fathers felt that the vote, which in final analysis is the power to set the policies and direct the affairs of the nation, should be restricted to mature individuals who could understand and have some vested interest in the necessity of maintaining constitutional government. Hence there was demand in the Constitutional Convention of 1787 that the right to vote be somehow restricted to responsible citizens. There were proposals that the federal government be assigned the role of establishing voter qualifications throughout the Union. All such proposals were based on the fear that individual states might grant the voting right to people not qualified to exercise it. The proposals were defeated, however, because of a greater fear. The fear of creating a federal government so strong that it could destroy state governments and eliminate God-given rights of individuals. Admitting the need for voter qualifications, which would keep the power of the ballot out of the hands of irresponsible people, the Founding Fathers felt there was a greater need to leave this basic attribute of sovereignty in the individual states. They rejected all proposals for constitutional provisions which would give the federal government any authority whatever in this field. Hence, President Kennedy's proposals for federal intervention in elections violate the intent, the spirit, and the provisions of our Constitution. The President's proposal that civil rights voting suits be given preferential treatment in federal courts violates the constitutional concept of equality before the law. Why should litigation by one class or color of citizens be given preference over litigation by other citizens? The President demands a Federal Fair Employment Practices Act to outlaw racial discrimination in private employment and in union membership. The President admits that 2/3 of the nation's labor force is already covered by fair employment practices laws of the very kind he requests. The racial problem is at its worst in areas that already have such laws, Washington, D.C. and New York City, for example. Yet, imposing a fair employment practices law on the 1/3 of the nation that does not have such laws, and that is demonstrably better off than areas which do have them, will, according to President Kennedy, somehow relieve racial tensions. The President asks congressional authority for the Attorney General to initiate in federal district courts legal proceedings against school boards and tax-supported colleges whenever the Attorney General receives a written complaint from any parent or student who says he is being denied equal protection of the laws because of segregation. What could be more unequal and discriminatory than to give one particular class of citizens the special privilege of bypassing the normal channels of justice which ordinary citizens must follow? An agitator or crank who happens to be a Negro can bring public school and college officials into federal court by merely writing a letter to the Attorney General. And the agitator will be represented at no cost to himself by officials and attorneys of the federal government. The civil rights proposals contain little that is really new. For the most part, the President merely used the racial crisis as an excuse for urging passage of new frontier legislation and demanding enlargement of existing programs. But the one feature of the President's proposed Civil Rights Act which is new is laden with danger. The President asks authority to force private hotels, restaurants, places of amusement, and retail stores to serve any customer demanding service. Any Negro could then bring any such businessman into court by merely making a complaint to the Attorney General, who would handle all the litigation at taxpayers' expense. If the businessman is innocent of any violation of law and chooses to defend himself, he must hire his own lawyer and pay all legal costs himself. The President says that the law would be constitutional because the federal government, he says, can constitutionally require owners to use private property in a way that is consistent with the public interest. Today, it is the demands of racial agitation groups which fix official notions of what is consistent with the public interest. Tomorrow it could be something else. President Kennedy recently announced that we must adopt a friendlier attitude toward the Soviet Union. It would show a friendly national attitude toward communists if all private merchants imported communist goods and sold them in their stores. The Civil Rights Act of 1963 would give the President ample authority to order such a thing if he should decide that any merchant who refuses to handle communist goods is not using his private property in a way consistent with the public interest. Under authority which he requests in the proposed Civil Rights Act of 1963, the President could order all private employers to hire communists if the President should decide that this would promote his program of proving to the Soviets that America has no ill will for communists. The President could order employers to hire or not hire Catholics, Jews, Presbyterians, Methodists, Mormons, Christian Scientists, atheists, black Muslims, Buddhists. The President could compel private businessmen to do anything the President wants on the simple pretext that he is merely requiring the use of private property in a way that is consistent with the public interest. Americans who value liberty, of whatever race, or however they may feel about the racial problem, should storm the Congress with demands that the President's Civil Rights Act of 1963 be rejected in entirety. This bill must be defeated. The President's Civil Rights message is a badly composed, hastily written, ill-at-ease document, replete with inaccurate statements, demagogic appeals to the emotions of hate, fear, and shame, contradictions, repetitions, flimsy arguments. Adam Clayton Powell boasts that he wrote most of the message. In all of American history, it would be hard to find anything more shameful than this. Adam Clayton Powell has been associated with many communist front organizations. He has been criminally indicted for income tax frauds. His tours of foreign nightclubs with his secretaries at taxpayers' expense has scandalized the nation, and his hatred for the white man has been openly expressed and broadcast to the nation. This is the man who says he told Kennedy what to say in his civil rights message of June 19, 1963. Adam Clayton Powell appears to be striving for the role of overall leader and spokesman for all the Negro agitation groups. It is Powell who is bringing the policies of all the groups into alignment with that of the black Muslims, who believe in black supremacy and advocate violence against whites. John F. Kennedy, catering to such people, is sowing the seeds of hate and violence, and the nation may reap a bloody harvest. Next week I will have more on the racial problem. Right now, a special word for all of you. If you approve of my broadcasts, express your approval to the people who make them possible, the sponsors. You can support these broadcasts by supporting the business firms which sponsor them. Without the sponsors, there would be no broadcast. I appreciate the letters that you write me. I would also appreciate you letting my sponsor know that you approve of his sponsoring this kind of broadcast. It is growing very late in the night of American history. It is not yet too late to restore the Republic. I believe there are enough Americans becoming aware that the Republic is sinking. And when enough of them do become aware, through the efforts of people like you who know and care, the Republic can be restored. I am Dan Smoot. Goodbye. God bless you. For a printed copy of this broadcast, send 25 cents to Dan Smoot, Dallas 14, Texas, and ask for 411. Civil Rights Act of 1963. 6 copies, $1.